G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and I'm talking to you today about obtaining a protection order, or what's often called a DVO, a domestic violence order. These orders have different names in different states, and because I'm a Queensland lawyer, I'm going to focus on Queensland law, which is the Domestic and Family Violence Protection Act 2012. I should say that on our website we have a brochure about obtaining protection orders. I would strongly urge you to have a look at that. I've talked in other videos about making sure that you have a risk assessment, because there's no point in obtaining a protection order unless you know what level of risk you have. Time and time again, I've been met with protection orders where they've been poorly drafted and risk hasn't been identified, the need for a protection order hasn't been identified, and the protection order has been, protection order application, I should say, has been dismissed. With care and thought, a protection order application will set out properly the domestic violence that has occurred. So it doesn't just need to be physical. It could be sexual. It could be emotional, for example. Many years ago, I said to a client who had been beaten black and blue by a husband and called all sorts of horrible names, which I won't repeat today. I said, what's worse? Is it the physical stuff or the names? And she said, I'll never forget it. Oh, the names. And of course I said, why? And her response, because the pain doesn't go away. So often being called names, the emotional abuse is minimised. Often sexual abuse is not referred to. If it's occurred, then it needs to be identified. If it's domestic violence, it should be set out. Most of my clients who have been hit by their former partner has also been subjected to sexual abuse. And in fact, having sex without consent, what we used to call rape, and of course is called rape, but is often identified as sex without consent, is in fact very closely connected with the physical violence. That lo and behold, when there isn't sex occurring, or the sex is of a degrading nature, or it's occurring without consent, that there is often physical violence. And if you think about it, it's not hard to envisage, because if you're prepared to hit your partner, then you're also prepared to sexually assault them. It's really quite simple. So obtaining a protection order for most people when they need to be protected is the way to go, but for some people, obtaining a protection order actually increases their risk. This is why it's important, as a first step, do a risk assessment. Look at our video about risk assessment. Look at our website for our brochure about risk assessment. Print it out, fill it out in pen, and then review it. And then once having done that, look at our brochure about safety planning. There's no point engaging in safety planning unless you've done risk assessment first. You've got to be systematic about this. You've got to be careful about this. Go to our website, look at our brochure about safety planning, and again, print it out. See what you need to do that you haven't thought of doing. But if you're at the point that you need to obtain a protection order, don't muck around. Get on with it. Several courts in Queensland will enable you to get a protection order, a temporary protection order, on the same day that you go there. If you're going to apply for a protection order, get it right first time. Now, we can help you, or we can help direct you to a service that can help you draft it. They can help stand there with you. They can take you to a court where you can be in a court where it's more likely that you'll be safe at court. What you don't want is that you end up in a court where your ex is standing right beside you at the bar table and has sat right beside you outside, intimidating you, frightening you the entire time, and what do? You give up. You don't want to be in that court environment. You want to be one where you are supported, where you know that the decision that you are making to obtain a protection order is the right one. Often police will apply for a protection order. However, my experience with police applications is that too often they go for a basic order and don't go for one that covers all the bells and whistles that are needed to ensure safety. If police have obtained a temporary protection order on your behalf, that doesn't mean that you can't do more. And the Domestic and Family Violence Protection Act is crystal clear that you have the right to be represented. And I know that because it's a section of the Act, and it's a section of the Act that I asked to be in there, because I was sick and tired of it being said that aggrieved people did not have the right to independent legal advice. You do, so you can have the police appear on your behalf, and you can have your own lawyer, and this lawyer might be a legal aid lawyer, stand up for you and say what you need, not what the police say that you need. A protection order can be made on a temporary basis, and it can be made on a final basis. Thankfully, some years ago, changes were made to the law to increase the length of time that protection orders last. When the domestic violence legislation first came in 30 years ago, protection orders lasted a year, too short. Then changes were made to the laws to allow protection orders to be made for 2 years. Again, for most people, a bit short. Some people it was appropriate, but for most people it was too short. You could get it for longer, but you had to convince the court why it needed to be longer in special circumstances. And I had a number of orders made back then that were 5 years. Now the standard is 5 years, and I think that's appropriate. Of course, you're not that's not written in stone, in the sense that an application can be made to vary that order, to discharge that order if needed, and that may be appropriate. And an order may be made to make changes to that order. So, for example, if it says no contact, and it needs to be loosened a bit because, for example, you've got property settlement negotiations or you've got to deal with your children, then there can be changes and tweaks made to it. Again, it's a wise idea to get legal advice before you go through that process. Please have a look at our website. Please go and look at our brochure. It's important to plan the process of obtaining a protection order carefully. Most applications for protection orders are not opposed. Most respondents will consent to a protection order being made without admission. This means that they don't admit they've done anything wrong, they don't accept what's been said against them, but they've agreed to an order being made, and if you're the aggrieved, that's what you want to achieve. You want to get an order. You don't care how you get that order, but you want to get an order. However, that's not a finding that the respondent has done anything wrong, but you've got your order. You've got your protection. If you're the respondent, there's often benefits in consenting to an order rather than fighting an order, because money might be better focused on what's occurring in the family court, for example, or a mediation, rather than fighting the terms upon which there might be a protection order. However, for some people, it is important that there is a contest about a protection order. And if you're the aggrieved, you should assume that might happen. Too often I have defended applications for protection orders where the aggrieved has not even contemplated the possibility that this could have happened. And lo and behold, they have been unsuccessful and my client has been successful. And that's because the application was not properly thought out, not properly particularised. In fact, in many cases should never ever have been brought. So if you need protection, look at getting a protection order. Don't have it as a standalone matter. It should be as part of a holistic process, looking at risk, looking at safety. Good luck. Thank you.